Good afternoon and welcome. I'm Elizabeth Slattery, Vice President of Practice Groups at the Federalist Society. Thanks for joining this conversation about the recent decision in Mirabelli v. Bonta and its implications for other gender secrecy school cases. As always, our usual disclaimer applies. The Federalist Society does not take positions, and all views expressed in this session belong to our speakers. Toward the end of the webinar, we'll open it up for Q&A from the audience, so please start thinking about your questions. Questions can be submitted with the Q&A function at the bottom of your screen in Zoom. Now I'm pleased to introduce our moderator. Eric Rossbach is Vice President and Senior Counsel at the Becket Fund for Religious Liberty. He's been part of the litigation teams in each of Becket's path-breaking victories, including Hosanna Tabor, Hobby Lobby, Fulton versus Philadelphia, and Mahmoud versus Taylor, among others. Eric has argued and won 2 cases at the Supreme Court: Our Lady of Guadalupe School versus Morrissey Baru, and Catholic Charities Bureau versus Wisconsin Labor and Industry Review Commission. Before joining Becket, Eric worked at Baker Botts in Houston, and he clerked for Judge Lee Rosenthal, also in Houston. He's a graduate of Haverford College and Harvard Law School, and Eric is admitted to the bars in DC, Texas, California, and Ireland. With that, Eric, please take it away.
Thank you so much, Elizabeth, and thank you to the Federalist Society for hosting this very timely event about a very important case in the field of religious liberty. And, I would say that you could call it the sort of sleeper religious liberty case of this term at the Supreme Court, Mirabelli against Bonta. And I'm really happy that we have 3 great panelists today to help us talk through this important case and what's going to come after that, and including some of the other cases that are pending. And so I'm just going to go ahead and sort of introduce all 3 panelists at once, and then we'll get into a sort of discussion or summary of the case, and then we'll get into some questions I have for the panelists, and at the very end we'll have some Q&A with the viewers. So first, let me just introduce our panelists. Peter Breen is Executive Vice President and Head of Litigation at the Thomas More Society. During his nearly 2 decades with the Society, Peter has argued and won numerous cases in trial and appellate courts across the country, including significant victories over the Biden and Obama Departments of Justice. Breen served 2 terms in the Illinois House of Representatives, rising to House Republican floor leader, where he led debate on hundreds of bills. Importantly for today's discussion, he was counsel for the applicants, the successful applicants in Mirabelli against Bonta. Our second panelist is John Bursch, who is Senior Counsel and Vice President of Appellate Advocacy at the Alliance Defending Freedom. John has argued 14 cases before the Supreme Court, including when he was Solicitor General of Michigan, and is serving on ADF litigation teams litigating numerous secret school transition cases, including one of the pending cert petitions, and still pending before the Supreme Court, Foote against Ludlow School Committee, and I'm sure we'll be talking about that case a little bit later today. And then third, we have Sarah Parshall-Perry, who is Vice President and Senior Legal Fellow at Defending Education. She was formerly Senior Counsel at the Department of Education and was also at the Office of Civil Rights within the Department of Education in the first Trump administration. Defending Education has filed amicus briefs in both Foote and Littlejohn, another case that we're going to talk about, and also maintains an active list of the schools that are socially transitioning kids, which is now more than 1,200 districts public school districts around the country. Defending Education also represented parents in a secret transitions case against the Linn-Mar school system in Iowa a few years ago. That was an early case in this space. So without further ado, I just want to set the table a little bit before we get to the discussion with our panelists. And first, I wanted to just point out that Mirabelli against Bonta may have sort of come out of the blue for a lot of people. But anyone who's sort of aware of this trend of the secret gender transitions at schools may not have been quite as surprised. And the reason is because, these policies have proliferated. And, what I'm talking about when I talk about, a secret transition policy is the gender transitioning of a child, so from male to female or female to male, that occurs at the child's public school with the help of school officials. So this is with their knowledge and their assistance, but without the knowledge of the child's parents. So this is the reason it's called the secret transition is because it's being kept secret from the parents. And these policies have been, as I mentioned, proliferating across the country. Sarah's group has a list of over 1,200 different school districts that have adopted these kinds of policies. And there's already been a number of different lawsuits that have come up through the courts on this, including some that have reached the United States Supreme Court. Now, before Mirabelli, the court had reviewed but denied reviewed, or looked at but denied review in several secret transition policy cases. But there were some opinions that various justices had written about this problem. And in addition to the Mirabelli case, which went up as an emergency application, so on the interim docket or emergency docket, I don't like the term shadow docket, so I'm not going to use that. But that went up on an emergency application. But there's 3 cert petitions that, as of this morning, and as of this morning's orders list from the United States Supreme Court, are still pending. And those are the ones I'm aware of. There could be another one, and hopefully my panelists will tell me if I'm wrong. There's only 3. Those 3 are Foote against Ludlow School Committee, as I mentioned, John Birch's case, Littlejohn against School Board of Leon County, Florida, and Levine against Great Salt Bay Community School Board. And the next conference that we might hear about any of the results with any of those is March 20th. So I'm just laying that out because we're going to talk about Mirabelli, but we're going to be talking about what happens after Mirabelli too. So Peter, my thought was that you could go ahead and start us off and try to give us as brief as possible, sort of, highlights real view of the case. I know you guys were in the trenches on this one for many years. So if you could just sort of give us a quick overview of both the case itself and then what the Supreme Court said the other day.
Sure. And the case started with Elizabeth Mirabelli and Lori Ann West, 2 teachers in the Escondido School District. And they had received a list, if you can imagine, you get a list of kids in your classroom who are transgender. And so there were 7 total kids on the list. 6 of them, they were told, the parents have no clue. And you are going to have to use different names and pronouns with the parent at parent-teacher night versus with the child in your classroom all day, every day. And so that was the beginning of the case. We filed suit in the Southern District of California, pursued it. We, unlike a lot of cases, we had success early on and won a preliminary injunction for the teachers. And in the preliminary injunction, the judge had noted parental rights and really focused on that. After that victory, we were hoping that we would get some cooperation from the state of California, and instead the Attorney General issued a legal alert attempting to undermine the district court's order and our lawsuit. So one thing led to another, and we started having folks come to us telling us other stories and having these terrible situations across the state. And we said, well, the only way to get relief for everyone is going to be a class action. So we amended our complaint, moved for class certification. After a lengthy, as you said, in the trenches, we did 26 depositions. And so we generated a full record below. We were able to secure summary judgment and a permanent injunction that protected both the parents who objected to these policies and the teachers who objected to the policies. And what was unique about our case, so we had a full record, unlike, a lot of folks are getting, a lot of the cases, you got knocked out of the box on the front end. But we had this full record. And really, when you look at what the experts actually said, I'm a former legislator. You can put a lot of words into, legislative findings and all of that. But when it comes to court, you have to put up evidence. And when the evidence was in, it was clearly in our side. The state of California, with all the resources in the world, largest law firm in the country, as I understand it, and again, unlimited resources, they couldn't come up with sufficient evidence to disprove our case or to prove their contentions of, grave and terrible harm with with the injunction against these policies. So we got that injunction. Well, that was on the 22nd of December. Well, 2 days later, the state of California files an emergency motion for a stay with the Ninth Circuit. The day after Christmas, the Ninth Circuit grants that stay. And at that point, we're looking at it. I've got a client whose child has attempted suicide, and that's how the client found out that the child was being transitioned at school. I've got another client whose school literally will not obey the parents, and these are middle schoolers and high schoolers. They won't obey the parents when they say this. Our child, is not that. Our child is a girl. This is the child's name, and so we said we've got harm that needs to be remedied. And so we did take the extraordinary step of seeking an emergency application of the Supreme Court. And that was pending for, I believe it was a little over a month. And of course, it's one of those things, you file it and you're watching other emergency applications get denied in the interim. You go, oh, well, there's a little more time on it. And then this past Monday, the court issues its decision. It was a relatively short decision, but it was very clear, we think. Common sense in the concurrence by Justice Barrett. She noted it was controlled by existing law. Now, some of that existing law is 100 years old, but that was really, we were very grateful that the Supreme Court really adopted those arguments, both the district court and our arguments, that this is really a no-brainer, to some extent for anyone who's got kids. You just don't expect your teachers to be doing things to your children in regards to their mental health or their health generally without you knowing, and then actually misleading you about it, and otherwise not obeying your instructions about how to raise your child. So that's the quick summary, Eric.
Wow, that was amazing that you were able to do that in such a short time. It's not easy to summarize several years of litigation in a few minutes. So thank you for doing that. I was, and also I just want to say we were also wondering, because the Beckett Fund filed an amicus brief supporting your application, and we were wondering, what's going on too. So it was definitely a longer time frame of sort of wondering what's going on here. So
well, and I will publicly say, I mean, when you've got literally you're measuring time in 24 hours to respond and things like that, it is extremely difficult on your legal team. And I want to thank Eric, you and the Beckett folks, your Mark and the whole team over there for your timely insight, just along with your amicus support. So it was very helpful to us. I appreciate that.
Yeah, well, very happy to be involved with a big case like this. And I guess one thing I would say is one thing maybe you could just elaborate a little bit is the sort of two different grounds that the court gave. So there's really two separate reasons that they were giving, and maybe you could just elaborate on that a little bit.
Sure. And everyone's familiar with the Mahmoud case from last year. Huge victory. I mean, a wonderful parental rights victory, but focused on religious liberty and the free exercise clause. And one of the problems we've had in the time since the Mahmoud case was passed down is you've got courts starting to narrow it and say, well, that was only a core curricular requirement. And so then there's this whole range of things in the school that apparently, were just being held by courts not to be subject to the free exercise right. So you had that issue. So in our decision, really, the high court pretty much, I think, put an end to that, or really, they, spoke the other way. And so strengthened that right and reiterated, yes, what we said in Mahmoud, we meant. But on the other end, the court issued a substantive due process ruling. And I know they didn't want to use the word substantive due process, but that's it's our shorthand. It was a due process ruling. And they're citing, going back to Sisters, the Society of Sisters v. Pierce, 1925, and pulling it forward and saying, of course, this is the parent's fundamental right to bring up their child, to educate their child. And one of the issues that we had been debating was, well, is calling a child a different name and pronoun medical treatment or what have you? And the court really went past that and just said, look, this can have bearing on mental health. And so that is part of the core parental right. So you can't deceive parents. You can't keep them in the dark. And we're grateful to the court for that clear teaching. We believe clear teaching and a good strong concurrence as well from Justice Barrett, who was joined by the Chief Justice and Justice Kavanaugh.
Yeah, and I think it kind of brought up something that it's an issue with all of these cases, and I think we can talk about some more in a minute, which actually came up a little bit at the Mahmoud oral argument, where Justice Kagan made this remark about, well, I'm not sure that non-religious parents would be so great with some of what's going on, with respect to the practices that were at issue in the Mahmoud case. And so there is this concern about making sure that, well, religious liberty is protected, but, non-religious, parents might be affected on these kinds of things too. So I do think that's like a really important thing that the court reached out and grabbed that, because it could have just decided it based on the religion issue, and it decided to go a little further. So I'm going to turn to John now and just ask him for his assessment, to the extent he feels comfortable, about, what do you think, John, is, the court's opinion? Did it expand the Mahmoud free exercise clause protection that it just talked about last term, or is this just an application? What do you see happening with the law of, that part of the free exercise clause?
I agree with what Peter just said, which is that the opinion on its face is broad, but lower courts have started to narrow it in unnecessary ways. And one key example of that is calling it a curricular decision. And therefore, if you have a context like this one, which doesn't involve curriculum, then Mahmoud doesn't apply. And I think the Supreme Court didn't hesitate to just wipe that objection off the books. And so to that extent, Mahmoud, at least to the lower courts, is now broader today than it was before Peter's big win in Mirabelli.
Right, because this is definitely not a curricular case. This is about stuff that's happening out, really external to the curricular or teaching process. So
exactly, and I think that he's right, and I'm sure you would have agreed with this, that Mahmoud should have been read broadly from the beginning to include non-curricular things. But that's not what lower courts have been doing. And this is a nice resetting of the chessboard to say, well, yes, this does apply across the board.
Right. And, one thing that I think got emphasized in some of the briefing in this case is that the case that Mahmoud was based on, Wisconsin against Yoder from years ago, the 1970s, involved whether the Amish had to go to school at all. So that wasn't really a curricular case either. So this sort of, narrowing it, post hoc narrowing of a Supreme Court holding is just not, didn't really make sense from the beginning, at least in my view.
Yeah, and you can see that happening in lower courts with the parental rights side of this too. In many of these cases involving the secret social transitions, lower courts would say things like, your parental rights end when you choose to send someone to public school. And once your child is in public school, the school gets to make all the decisions. And this case wipes that away. Some courts have said, well, parental rights doesn't mean demanding information. It only means being able to act on information you already have. But again, this wipes that away. So courts have spent a century limiting parental and free exercise rights, and Mirabelli puts a stop to all of it, which is one of the things that makes it so extraordinary.
Yeah. So let me turn to Sarah now and ask, what do you think about the sort of, what the court was doing with that, what I think John was just referring to as sort of parental rights, but more broadly, you could call it the Pierce-Meyer right. So those are the sort of two older cases from the 1920s that the court relied on. How do you see that? Does it expand it? Is it just a mere application to these facts, or what do you see happening based on Mirabelli with that right?
I think it's a pretty clear, direct application, and there is tons of precedent. Obviously, we've got over 100 years of jurisprudence on the 14th Amendment parental right, as recognized first in Meyer versus Nebraska in 1923. But remember, those particular cases relied on the fact that parenting in and of itself is intrinsically rooted in natural law, right? So we've heard everything from St. Thomas Aquinas and Summa Theologica to John Locke's Second Treatise of Government to Sir William Blackstone's commentaries, all of which reference the longstanding, enduring nature of that sort of precious family relationship, parental right. So to say that, yes, we're having to sort of apply that shadowy ether of the substantive due process none of us like as conservative jurists or conservative scholars, is, I think, subject to, and was distinctly in this case, the limiting principles that we find in cases like Washington versus Glucksberg, which is this deeply rooted in the nation's history and tradition? And we have a long-standing tradition of recognizing the strength of those familial bonds and the importance of a parent's right to actually direct their child's upbringing, both in education and beyond.
Great. Yeah, I think that's a really, I mean, it's an interesting question. In some ways, if you look at some of the recent historical scholarship about Pierce, like if you go back to look at the docket books from the Taft court, Chief Justice Taft actually referred to it as a religious liberty case, apparently, in conference, the Pierce against Society of Sisters case. But there was also a secular school in the case. There's a military school from Oregon that was in that case. And so you sort of see a dynamic where you've got the religious entity in there, and maybe that's sort of the pointy end of the stick or whatever, the tip of the spear, I guess, is the metaphor I'm looking for. But then it ends up sort of covering a lot more people.
Yeah.
So well, I'm wondering, John, maybe you can talk about this a little bit, but like, since you have a case pending right now, which is just substantive due process, right? The Foote case, I believe you just have a substantive due process claim in that case, or at least before the court. What's how do you see these two rights interacting? Because Mirabelli says parents have both kinds of rights. The religious parents would have the religious freedom right, but then all parents, including the religious parents, would have the Pierce-Meyer right. So how do you see these two interacting? Like, is the religious one just going to become irrelevant, or what do you think?
Well, I think in the long haul, the religious principle may become less relevant in the parental rights context. As you mentioned, Justice Kagan at the Mahmoud oral argument saying, well, wouldn't non-religious parents want the same right? That's basically the way that we framed the Foote cert petition, is that you now need to do what you did in Mahmoud in the context of parents who have moral, religious, ethical, and medical reasons to object to their youngsters being transitioned at school, but don't have religious objections. And so I think this case signals that at least the majority of the court is going to be willing to do that. Whether Mirabelli is the last word on this, or whether they take one of these pending petitions and do a full-blown merits opinion, that's still kind of open. But I don't think it necessarily works the opposite way. So, for example, the Mahmoud principle could be invoked in a context that doesn't involve parents. And I think that over time, the Supreme Court, at least as it's currently constituted, is likely to take that principle and apply it outside of parental rights. So in any context, if you're a person of faith or you're a religious organization and there is a substantial impingement of your beliefs, then strict scrutiny should apply, even if the law is neutral, generally applicable, and was enacted without animus. There's no reason why this principle couldn't apply to that case. And if that's true, that takes care of many of the post-Smith problems. On the one hand, if you've got a speed limit law, that might be something Justice Scalia would have worried about when he wrote Smith. That's not going to be a substantial impingement on your religion if you believe that you should be able to go 90 in a 55 zone. The courts just won't accept that. But if you've got a dry county and there's no alcohol sales, no alcohol consumption, and it prevents the Catholic Church from using wine sacramentally at Mass on Sunday, that is the type of substantial impingement that Mahmoud suggests would allow strict scrutiny to apply, so the church wins that dispute. And that can be true without any parental rights claim attached to it. So I think the parental rights notion that Sarah was talking about and the Mahmoud free exercise principle each have work to do. But when it comes to religious parents in schools, most likely, I think the parental right eventually will be the one that the lower courts focus on.
So would one way to sort of recapitulate what you just said is that it's sort of, there's a Venn diagram, but it's, it's not, the Mahmoud right isn't completely inside the circle of the Pierce-Meyer circle. It's overlapping, but not entirely, coincident.
Exactly. When you got parents who aren't religious, they have rights that Mahmoud may not affect, but Mirabelli may now affect. And if you've got a religious plaintiff in a case and they're not in a parental position, Mahmoud could still give them relief that the Mirabelli case would not address.
Great. Okay, so Peter, I'm going to ask you a really hard question because it's your case, which is just, there is this issue that's already been commented on, by a number of people, which is the phrasing of the per curiam. I don't believe the word substantive comes up in there. The word due process comes up, but it's sort of referring to what you argued as opposed to what the court is necessarily applying. So, and of course, Justice Kagan talks about this in her dissent and says, well, they're not wanting to talk about substantive due process. So, did the court actually rely on substantive due process, or was it trying to sort of leave the door open to replacing the theoretical or constitutional basis for the Pierce and Meyer decisions? And if that's the case, is this going to be, what Justice Thomas has argued for many years, which is replace substantive due process with privileges or immunities clause? So that's the really easy question that you get to field.
Well, and of course, you're sitting there. I mean, try to figure out, what an appellate court is thinking. You got to be very careful of that. It's almost, you never know. But when I look at what they did, they obviously didn't use the word substantive. So Justice Kagan was correct about that, and they made a choice there. I think we'll see what that, down the road, what is the thought there. I think John, I appreciate John's optimism that they're actually going to expand that parental right for all parents instead of just, the more religious minded parents. I know as we're trying to advise folks around the country, get your opt-out form in, get your objection in, try to express that you have a religious right of some sort. It certainly would be better to say, look, parents are just in charge of this. The court said that in a few places, and so. I do think, when they say that, parents, not the state, have the primary authority with respect to the upbringing and education of their children, or, noting the policies cut out the primary protectors of the children's best interests, the parents. Again, for us who are parents, you're sitting there going, of course, but it's been a tough road to get here on this. So, whether that, how the court is, they kind of leave themselves an opening, and you don't necessarily go down there. They don't have to go away from the substantive due process, but it's there if they want to, and we'll see. And for such a short opinion, it really it could have a lot of implications that, we're not even thinking about right now.
Yeah, I think I'd love to add to what Peter said. Yeah, I'd love to add to what he said. Mahmoud was easy, I'm using air quotes, in the sense that it was a direct application of Wisconsin versus Yoder. It was very clearly related to religious parents and precisely their interest in directing the religious upbringing of their children. Now we have to wrestle with what I think many of us have been loath to address for a while, and has been largely sort of a tool of more progressive jurists in the past and activist courts, which is substantive due process. And yet, because we have limiting principles like those articulated in Glucksberg, like those who specifically related to inherently sort of fundamental to the nation, to the notion of ordered liberty, and deeply rooted in the nation's history and tradition, both of which are obviously evidenced within longstanding regulation and recognition of the parental right. I think this is an easier sort of circle to square for the majority when they have to wrestle with the issue of due process head on. And I think it is entirely consistent with, for example, the Dobbs versus Jackson Women's Health opinion, which came up in Kagan's opinion, in which she was mentioning, listen, you've already told us that you don't like substantive due process. Now all of a sudden we're seeing it employed by conservative jurists. We don't like it. We have to be consistent. And I think the two are consistent in that those limiting principles in Glucksberg that were identified and recognized in the Dobbs decision are also consistent with what we saw in Mirabelli, and what I think we're going to see also in the gender secrecy cases yet to come.
Well, you anticipated one of my questions, which was just, Justice Kagan definitely did say that this is inconsistent with Dobbs or in tension with Dobbs. And so I'm wondering first, John, if you want to address the issue about, what's whether substantive due process, but also, either John or Peter, maybe address also that issue about Dobbs, or how's this, how can this be reconciled with these earlier decisions? So John, I don't know if you wanted to address the issue about whether substantive due process.
Yeah,
or-
I'm happy to address that. And
Great.
it's mostly to echo what Sarah and Peter have already suggested, which is that as long as the Glucksberg deeply rooted rights, bars, guardrails, if you want to call them that, are there for substantive due process, then it looks like 5 justices, all of the justices in the majority in Mirabelli, except for Thomas, are already there, because not a single one of them joined Justice Thomas's concurrence in Dobbs, suggesting that the whole framework needed to be moved into privileges or immunities. I do think the reason why they didn't actually use the phrase substantive due process here was to keep Justice Thomas from writing some kind of a separate opinion objecting to the notion that this could be considered a fundamental right. But whether it's substantive due process with guardrails or whether it's privileges or immunities, I think the answer comes out exactly the same way. And there's some good scholarship. Professor David Upham at St. Thomas in St. Paul is going to be writing an article that's going to be published in the upcoming Notre Dame Law Review that addresses this issue and says you can look all the way back before 1868 and find some parental rights type protections in U.S. Supreme Court decisions. So when you're talking something that's as old as Blackstone's commentary, as old as Thomas Aquinas' Summa Theologica, it's not difficult for the court to say, yes, we've got a constitution that was built on some fundamental rights that we're going to recognize, and it doesn't really matter what clause it is. So to me, the only interesting thing is an academic question of how this will play out in future court opinions. But I don't think that the doctrine of parental rights is going to go anywhere based on Justice Kagan's dissent.
Great, that's very helpful. Peter, I don't know if you want to weigh in on the sort of conflict with Dobbs or perceived conflict with Dobbs, or we can head on to the next topic, whatever.
I'll tell you, the one thing, and when you're looking at Justice Kagan's dissent, the thing that I pulled away from it was that Justice Kagan and Justice Jackson recognized almost, in a little bit of a backhanded way that we were onto something here. They said, of course, parents have rights like this. And so I think that's really the one thing I take from their opinion on that front. And I think the differences with Dobbs are pretty, you can raise that, but for heaven's sakes, I mean, there's nothing deeply rooted in the nation's history about abortion. I mean, for heaven's sakes, it was outlawed for most of the nation's history. So you can't really compare that right to taking a child and changing their gender presentation, their name, and doing essentially amateur mental health treatment on that child in a school.
Great. Okay. Well, that's really helpful. And I would like to segue sort of into this question about where are we going from here? And I think the very first practical question, I'm going to direct this at John, since he's the one with the pending cert petition, perhaps surprisingly still pending as of this morning. Nothing happened in the orders list that was released earlier today. So, and I think we already have a question sent that was posted into us that said, what's going on with Foote and Littlejohn? And of course, there's a third case called Levine that I mentioned earlier that's in there. So what's going on? You've been relisted how many times now in the Foote case?
Well, we've been conferenced 9 times. And then there's a case that we kind of consider a companion case because we tied it together. And that's Littlejohn, the one that you mentioned, which has been rescheduled almost that many times, but not conferenced yet. And then in Levine, I believe the reply brief was filed on Friday. And so it'll be conferenced for the first time probably at the end of this month. Your guess is as good as mine. I thought for sure that today Foote would be GVR'd back to the First Circuit so that they could reconsider it in light of Mirabelli. However, I think that Justice Kagan and Justice Jackson in their dissent may be our biggest cheerleaders at conference, saying, look, if we're going to do this, let's do it with full merits briefing, oral argument, and a merits opinion, not this per curiam stuff. And then we can really get at the roots of where the parental rights notion should be grounded in the Constitution. We can answer some of these collateral issues that lower courts have raised about limitations on parental rights. do schools have to affirmatively disclose this type of stuff, or is it just enough that they don't lie to parents when they're talking to them? Those kinds of things. So I would still be delighted to see that they took the case. I think there is more for the court to say about this. That said, Mirabelli was a pretty comprehensive opinion, as short as it was, and it resolves a lot of things. So we'll wait and see.
I mean, I think it's a remarkable. It would be remarkable if they ended up granting in your case or the Littlejohn case or the other one after having decided Mirabelli. But you're right. Like the critique from Justice Kagan was that there wasn't enough. We're doing this on per curiam. We really need. So I do think that that's an interesting possibility. So, and just more generally, I know you're working, and maybe Sarah can address this, or Peter too. There's a lot of, the cases are not all at the Supreme Court, right? Like, I think there's a lot of these around the country. So do you want to just sort of say, like, how do you see Mirabelli affecting those? What are going to be the next issues coming up? And this is really for all three of you to have a chance to respond to. So maybe John.
I can take a first stab at that, because we have a number of these cases pending. And I think number one is a policy point that I expect that public schools across the country are going to abandon these secret transition policies, because now if you've got a policy in place and a child transitions at school without their parents' knowledge and then hurts themselves or hurts someone else as a result of not getting proper mental health treatment, that school is going to be on the hook, because you've got a Supreme Court case that tells them that this is unconstitutional. So all that qualified immunity stuff kind of goes out the window. So if I'm advising a school board, it's okay, you've got to be frank with parents starting immediately. And so this should result in the prompt repudiation of these policies across the country. As far as the pending cases, if I'm on the school district side, I don't want to see the fees continue to be run up for something which has a now nearly certain end. I'm probably settling these cases as quickly as I possibly can. And so if Mirabelli has that effect where we eliminate the policies, all pending lawsuits, the parents and children get relief, and we kind of like reset the board and we go on to other parental rights fights, that's the best possible thing that could happen.
Yeah, I would add to that. And I would say that there's probably going to be sort of a rationale that cuts both ways, right? So as we see sort of the strengthening and the reinforcement of the 14th Amendment parental rights, there was an issue that was not taken up by the Supreme Court in the U.S. versus Grametti case, and that was whether or not the parents had a parental right to actually seek so-called gender-affirming care for their minor children. Now, I've written separately a legal memo actually indicating that that is not a parental right as traditionally conceived, and that there is no right to achieve controversial, sort of unproven medical care for one's minor children. A case directly on point is Abigail Alliance for Better Medicine, coming out of the DC Circuit in 2017 approximately. And that's where the Supreme Court said, even though these patients wanted access to what they conceived to be life-saving medicine, which was not approved by the FDA, the court determined en banc that this was specifically something that was best left to the reasoned medical judgment of those professionals who were dealing with treatments for different things. So we're going to see, I think, sort of a battle on perspectives from expansion of so-called gender identity within public education and within healthcare, and on the other side, sort of what that does to the religious liberty interest and whether or not it essentially implicates exactly what's happening right now in public schools. But we have yet to see the Supreme Court take up the question specifically as related to so-called gender affirming care.
Yeah, I think that's a really crucial question, because at first glance, it seems like there's sort of a parallel claims, but then as you say, like it does matter what the sort of medical discussion is about this. And I'll just say from the sort of religious liberty standpoint, like that's one of the areas that's kind of an easy area of law with respect to a religious liberty claim. It's very common, for example, Jehovah's Witnesses don't believe in blood transfusions, and hospitals routinely go to court and get an order saying, I'm going to get a blood transfusion for this child because it matters, they're going to die otherwise. And so the religious rights of the parents get, sort of overridden. So I do think it's a very interesting kind of thing, because there is this sort of first glance similarity, but when you dig into it, it does seem to be a little different. I don't know if, Peter, did you want to address that issue or any other sort of like upcoming?
Yes. It was interesting. I saw a question pop up in the chat, and so a couple points here. I'm in San Diego right now. That's why you've got a hotel room behind me for our attorney fee hearing. We've asked for over $4 million for our attorney fee work, or for our attorney work in the district court. But folks may not realize, on Friday, the state of California filed an emergency motion on us to try to essentially modify the Supreme Court's vacatur order. And so the other side is not necessarily backing down on this. In our experience in the past, when the Supreme Court speaks, state of California, for the most part, obeys. But I don't know that they're going to do that here. At the same time, somebody had asked about enforcement in the state of California, and the California School Boards Association, which has got 1,000 school boards in it, has issued a notice to its members that is more robust and instructs them, hey, you better follow this. And to John's point, this is now a clearly established right. Folks are subject to individual liability on this and damages potentially. And just as a note, the California State School Board Association, in their advice to their members, they said the teachers are likely to win their claims when we get the whole thing heard eventually, assuming the state doesn't settle the matter. So there's going to be some back and forth here, I think. I had heard the other day that the state of Colorado had actually filed something in a court that denigrated the Mirabelli decision, or said it wasn't applicable in some way. So I'm, unlike some of the other times when the Supreme Court has spoken, I don't know that this is going to end soon. The other side really may fight this like crazy, and maybe the Supreme Court needs to. I'm hopeful the Supreme Court takes John's petition or one of the other very worthy petitions on this topic to maybe they're going to have to do the same thing again. What Mirabelli did for Mahmoud, maybe you're going to need another decision to do the same for Mirabelli.
Yeah, I mean, I do think that's a pretty interesting possibility. With the polarization around these issues, sometimes the incentive structures don't always follow the way that the law has been laid out. And sometimes people will fight battles that they know they are probably going to lose because they, personally or in some other way benefit from continuing the fight, even if it's a sort of quixotic quest at that point. So I'm hopeful that everyone will see reason, but I'm not not relying on that. I also wonder just if we could talk a little bit about that broader issue, and then we have a couple of questions in the Q&A that I want to get to. But just sort of the broader issue, which John sort of averted to earlier, but just even outside the school context. So outside the secret transition context, outside the school context, necessarily, but within the school context, but just outside this fact pattern, where do you see the Mirabelli case having a real impact or changing the direction of doctrine?
Well, one case we have pending right now that it would appear to have immediate applicability are overnight trips, where schools will secretly assign a male who identifies as female to the same hotel room, sometimes the same hotel bed as a female athlete or field trip participant. And if Mirabelli is right, then it seems it would apply with full force to that situation as well. And you can imagine other things like that coming up.
Well, I do wonder about the athletics question more generally. Like, what is the effect on, transgender children in athletics, and people trying to be on a different team than their biological gender? I don't know who wants to address that, but or who, Sarah,
Yeah.
you want to?
I think we're unlikely to get an actual definition of sex from the court, but in the colloquy between the ACLU attorney and Justice Alito, he asked specifically for purposes of equal protection analysis what the definition of male and female was, what it meant to be a girl, what it meant to be a boy. And the ACLU attorney responded, I don't have an answer for the court. So while I don't think they're going to pull a definition of sex, into the actual assessment, I think it's going to have implications that are related to this space generally because of what we've seen as the proliferation of sort of gender identity related policies, whether with pronoun use, athletics, facilities accommodations, or these school secrecy policies. All of them really are a harbinger of, I think, what we're going to see in future litigation. I'm fairly hopeful, and I think maybe the panelists would agree, though I'd love to hear if they don't, that the challenges to the Idaho state law and the West Virginia state law are both going to be successful. We still obviously have an active regulation on the books related to Title IX of the Education Amendments of 1972 from the Biden administration. So even though we've seen vacatur in two different federal district courts and either permanent or temporary injunctions in others, that Title IX era rule can sort of be zombified and resurrected. And so I think what we're going to need from an administrative standpoint is probably rulemaking on that as well, that helps shore up a lot of what we've seen right now in terms of the state legislation on athletics and athletics sort of implicated policies related to overnight trips and the like.
Yeah, and Peter.
And Eric, I can comment briefly on
yeah,
briefly on BPJ and Heacock, since we're co-counsel to Idaho and West Virginia in those cases. Coming away from the oral argument, we were very encouraged that the court is going to hold up the Save Women's Sports Acts in both of those states. But if you want to think about the interplay between that situation and this one, they could resolve sports, but still leave open the question of locker rooms and bathrooms and things like that. And those might be answered differently. They might be more difficult to answer under Title IX and equal protection theories. But if parents come in and they say, well, we want to have notice that there's a male student who's in the female locker room undressing and showering with my daughters and then opting out, and you see mass opt-outs at the public school level, through parental rights, you could end up having a policy changed and acknowledging that practical position without even litigating the Title IX and equal protection issues. And so that's where there might be some overlap.
Great. Well, Peter, did you want to weigh in on that? I have a question for you next, but you might want to weigh in.
Okay, well, no, and John's point is a very good one, that we are going to need to activate parents in a way that maybe they have not been so far. And certainly, we had two named plaintiffs, two teachers. They were essentially driven out of the district. They were harassed mercilessly. And so when we added plaintiffs, obviously the parents would proceed via pseudonym due to the sensitivity of the situation with their children. We had additional teacher plaintiffs who came in via pseudonym because they didn't want to have the same thing done to them. So, I mean, there is a feeling with the parents, you don't want to be the only one objecting, but if we can help folks, encourage them in groups to object, that really can drive change because they would vindicate their rights. And we're doing that in certain places across the country. It's a little less litigation, a little more maybe public policy work, but I think something that's necessary for whether it's the public interest law firms or the other advocacy groups who are working in this space.
That's great. And that's a perfect segue to my question, where I'm going to start pulling some questions from our question and answer function, which I encourage people to add questions there. I can't guarantee we're going to get to everything in the remaining time, but one question that your comment just now affects, which is the teachers. We did have a question like, what happened here? The teachers didn't get relief. The parents did. What happens to the teachers in Mirabelli?
Well, in the immediate term, having the parents get full relief and such, with such good, strong language, ideally will help us to protect the teachers in the short term. The teachers' rights really were, the derivative is maybe not the best word, but they were tied together with the parental rights. And so by having those parental rights vindicated, we are hopeful. Now, one of the problems is if we get some folks on the other side who are very ideologically minded and they're trying to push and prod and really find the limits of this, maybe to make life uncomfortable for particular teachers in particular districts, we may have to go back to court on that point. But again, our hope is that everyone gets protected by the ruling of the court. And again, the California State School Board Association, which is the group that worked with the state to implement the bad policies we were challenging in Mirabelli, their advice to their members is, the teachers are likely going to win too. So hopefully everyone just follows that and we don't have to fight it out further.
This is sort of like John's hopeful comment that everyone will just get rid of these policies because they read the opinion. So again, hope but verified. In any case, the next question from the Q&A that I want to get out there, and maybe this is a good one for Sarah, is the question of pronouns. How does this affect pronouns within school? Is it just part of the transition issue, or what's going on with that? So I don't know if you want to specifically address that.
Yeah, absolutely. So the social transition issue, I mean, even the World Professional Association of Transgender Health, WPATH, has said that social transition is not a neutral intervention. It is, in fact, an active first step toward what is generally ultimate medicalization for these children. And part of that social facilitation is not just these gender secrecy plans, but it's also the facilitation of things like different names and preferred pronouns. Now, we just saw the Fourth Circuit utterly botch the analysis on precisely this claim of a teacher out of the Fourth Circuit in a case called Polk versus Montgomery County School Board. Yes, that Montgomery County School Board that had to get its wrist slapped very roundly from the Supreme Court in the Mahmoud versus Taylor decision. But they actually applied the Garcetti versus Kapalos analysis, saying, listen, she doesn't want to use preferred pronouns and she doesn't want to keep secrets from parents, but this is part of her official duty as a government employee. I think that's entirely the wrong outcome. So I think we're going to see more litigation, and I'm hopeful that as part of that, it'll be Peter's case eventually being able to vindicate the rights of those teachers as well.
Great. Okay, I've got another interesting question. And maybe this is a good one for John, but obviously others should feel free to jump in, which is, what do you make of the difference in the per curiam's discussion about the levels of scrutiny? So basically we have a question here in the Q&A about whether there's heightened scrutiny with respect to the Pierce-Meyer, right? But strict scrutiny, which is the normal one for free exercise clause at Mahmoud. So what do you make of that difference? Do you think that's chosen specific language, or what's going on there? So John, I don't know.
I think that's a perfect example of one of those things that probably needs some additional thought and writing in a full merits opinion, which would justify granting the foot petition or another case. Yeah, I think they're just leaving themselves an out, like Peter said, that maybe there'll be some circumstances where they don't want to apply full-born strict scrutiny for a parental rights claim. Sitting here, it's hard to imagine what that would be. The lower courts for the last 100 years have generally applied strict scrutiny whenever they see a parental right that's invoked. But that's the whole dispute in the Littlejohn case, where the lower courts applied a shocks the conscience standard instead of strict scrutiny to a parental rights claim in a context just like this, with facts involving a secret transition. So maybe that leaves it open where they grant Littlejohn and Foote together and resolve all those questions in one fell swoop. I don't see it as a signal that parental rights advocates need to be worrying that somehow that right is going to be watered down by the Supreme Court. If that was going to be the case, you wouldn't have seen this amazing Mirabelli opinion to begin.
Yeah. And I do think we need to reemphasize that it is an amazing opinion. It's a lightning in a bottle. Peter, I wonder if you could answer one of the other questions we have, and feel free not to, but which is just when does the Mirabelli right come into force? So what triggers it? And the question is sort of that's in the Q&A is about if the teacher notices something, when do they have to start telling the parents? So that's yeah.
I hear it. And to some extent, we had to make certain decisions as part of the litigation process, where we wanted to make sure that our claims were they're narrow and particular to the needs of our clients. But when you read the Supreme Court's opinion, they went a little broader and did establish some better frameworks as the highest court in the land would do. So right now, what have you got in place? You've got an injunction against parents being misled. So the injunction that the Judge Benitez at the trial court entered was not an affirmative, you must immediately notify a parent. They left a little bit of wiggle room there, but now you're on notice as a school district and as a teacher corps. You can't do this in secret. And so I think the court left school districts a little bit of room to establish policies to figure this out. which is appropriate. I mean, that's, we're not, the court isn't the executive branch or the administrative state, as it were. So, where that right comes down, I think it comes in pretty quickly. Certainly, because if you're a teacher and you start using a different name and pronoun for a student in school, you know, you, if you don't notify the parents pretty quickly there, certainly you are, you're dancing on the line. I mean, I wouldn't want to be that in that particular situation. So my hope is that these school board associations, and there are plenty of lawyers who do that work full time. They'll lay down policies that will be protective of parents' rights. And at least again, having been in government before, school board lawyers are usually pretty careful. So I am assuming we will hopefully get good, strong parental rights protections with those policies.
So we have about 2 minutes left. So I want to just give people anything else they want to add before we have to wrap up. So any of our panelists, if there's something we've left out or something you just want to make sure people take away from this, that would be great. So Sarah.
Well, we just mentioned pronouns, and so I have to brag on our litigation team specifically because we secured an en banc victory coming out of Ohio in the Olentangy Public Schools case that we challenged as an organization, and that was specifically related to the rights of children not to have to use compelled pronouns and for their parents to be able to oversee what was transpiring on social media apps and on personal devices when they were home. This was an anti-harassment policy coming out of Ohio. We secured a victory en banc. We are very encouraged by that. That now makes the Sixth Circuit fairly fulsome in terms of its analysis on First Amendment rights vis-a-vis free speech. We've also seen it in the Meriwether versus Hartop decision written by Mulf Thapar for a college professor's right not to have to use preferred pronouns. So I think there will be certainly more litigation on the pronoun front.
Thank you. And John and Peter, quickly in our last minute.
Go ahead, Peter.
Oh, okay. Well, again, I think we are, we're very grateful for this decision from the Supreme Court. But I think it is something, as you've heard here today, there are a lot of other threads to pull. There is a lot of work to be done. So I would say, this is more of a beginning than an end to some of these issues here and some of the disputes that are going to continue. And so I'm honored to be on the panel and have great friends like John and my new friend Sarah. And of course, old friend Eric, who have been working so hard on this, and thank you for that opportunity to address the issues.
Yes. Well, let me just say thank you to all of our panelists. I do think that Peter's last thought that this is sort of the end of the beginning, or rather than the beginning of the end, is pretty appropriate for this area. And maybe we'll end up having another FedSoc webinar about similar issues in the future. So again, thank you to all of our panelists, and thank you to the Federalist Society. And I think we will wrap things up.